Good morning, everybody. Welcome to Thursday, the 30th of April. Goodness me, it's amazing to think that we haven't had 6,000 days in April and in March, I must say, with the current circumstances. I realise I'm a minute early, but I had some difficulty with with going live yesterday morning, so I thought sensible to get up here a minute early this morning and make sure that that everything is working as it should. Good morning, Mish. Thank you so much for joining us. It is a miserable day out there today here in Armidale, where we have a forecast for the next few days of this polar blast. We'll be lucky to reach double digits during the day, so it's going to be cold. So we are now at 9:15. So welcome to everybody who is going to be joining us this morning. Fantastic to see you. Welcome back to our regulars and to people who might be joining us for the first time. So as of today, we've been doing this now for 5 weeks. We are live at 9:15 every weekday morning with updates on new information to do with the COVID-19 situation as it applies to employers and employees, and also more detailed information about topics relating to staffing management and to business management. So a huge warm welcome from me. I'm Bronwyn Pearson from Pinnacle People Solutions, and our company provides human resource services, solutions, advice, support to regionally based small to medium-sized businesses and not-for-profit organisations. We are here to help you through these very challenging COVID-19 times. Please ask any questions that you might have as we go along this morning. If you ask them in the chat screen, I can look here and see them. Outside of this, you can contact either myself or a member of my phenomenal team anytime. You can do that via direct messaging in Facebook or email or phone. I'm sure my team are going to be getting those contact details up for you in the chat screen presently. So please don't hesitate to make contact with us. We're very happy to help. So this morning, Thursday, the 30th of April, what are some of the breaking news items or changes that have been announced since yesterday, the 29th of April? So let's have a look at those. So I did mention this yesterday morning, but I think it's worth mentioning again because it's a bit exciting. And that is that in New South Wales from this Friday, so tomorrow, 2 people can visit another's household. So that's really exciting. Obviously, we still need to be incredibly vigilant. We still need to maintain social distancing obligations, and it's incredibly important that we do not compromise the elderly or those who might be immunocompromised or otherwise vulnerable. So please just be really careful before you go visiting anybody, that you're doing so, safely, and you're maintaining the health and well-being of those that you're interacting with, as well as yourself and your families, of course. Okay, so that announcement is a very welcome one. In terms of JobKeeper, which is a deep dive for us today, looking at the JobKeeper Enabling Directions, and we're going to look at some case study information around that for you today. So when we're talking about JobKeeper, the good news is the ATO Commissioner has extended the enrolment for JobKeeper from today, the 30th of April, to the 31st of May. So that's really, really good. I would still, as I did yesterday, strongly encourage you to please get your enrolment in as soon as you possibly can, either yourself or through your tax accountant or your bookkeeper, as soon as you possibly can, because the earlier you get it in, the more quickly you will receive reimbursement from the 30th of March, assuming you've been eligible. from that time. So the other change that has come in is that you now have, as an employer, until the 8th of May. So it had been the 30th of June today, but it's now been extended to the 8th of May for employers to pay eligible staff the JobKeeper amount, which is the $1,500 a fortnight before tax. The first 2 fortnights of the JobKeeper scheme, which are from the 30th of March to the 12th of April and the 13th of April to the 26th of April, the ATO will accept the minimum payment of $1,500 provided it is paid by the 8th of May. So you've got 8 days from today to make sure that you have complied with that. You must pay your employees by that date. Otherwise, you'll not be eligible for JobKeeper for those 2 initial fortnights. So please keep that in mind. Very important for you to know. We will pop up and my wonderful team are right on it, putting up the links to the things I'm referring to as we go through today. Thank you so much. I'm sure there's many of you listening who are employers with teams you are immensely grateful for. I am certainly one of those, and I appreciate their resilience and their humour and their hard work at what is a very difficult and somewhat unpredictable time. So what I would also mention again today that I mentioned yesterday, but I think it's worth saying, particularly in the context of this morning's topic, that significantly and importantly, particularly for regionally based business, which is our area of specialty, an alternate test now applies where your business was affected by drought or another declared natural disaster, bushfires, for example, during the comparison period. So where you're trying to establish your eligibility for JobKeeper by comparing your turnover from, a particular time now to, as had originally been the case, a relevant time, comparable time period in 2019, the feedback that the government had from businesses who were drought and otherwise impacted by other natural disasters also was that, well, that's incredibly difficult to do because we've been impacted by drought and or bushfires and or other natural disasters for the last however long. So comparing 2020 to 2019 is probably not realistic because that wasn't really representative of our income either. The good news is that an alternative test for assessing that turnover has been introduced. My team have just put up the details there for you. And that is important. They've also got alternate tests up there for startup businesses and those businesses that might operate through different kinds of structures or different entities. And the rules about qualification for the package have been expanded, as I mentioned yesterday. If you're in doubt, please get in touch with us or talk with your accountant or bookkeeper. Very happy to help you to determine whether these new rules mean that you will have eligibility when maybe a few days ago or a day ago you thought you wouldn't. So really important to keep checking that out, and we'll keep you updated as we have been every morning on any modifications or updates or clarifications that come through that will help to clarify your potential eligibility for JobKeeper as a business. The other clarification that's come through around JobKeeper is that employers must nominate all eligible staff on their payroll for JobKeeper. You can't pick and choose. We've had this question come up numerous times, and clearly there was either confusion or perhaps an attempt to try and claim for some staff but not others on the part of employers. The ATO has made it really clear, the guidelines are really clear now, that employers must nominate all eligible staff for JobKeeper. You can't pick and choose. So whoever's eligible on your payroll at the time that you are enrolling for JobKeeper must be the staff that you apply for and pay the JobKeeper allowance to, wage subsidy, I should say, to, if you are deemed eligible. For those who are locals to us in the Armidale region, good news overnight that Rex Airlines, Regional Express Airlines, has announced that following confirmation that they're going to have some additional funding from the federal government and several state governments, they're actually going to be resuming services to Armidale, offering 2 return weekly services from Armidale to Sydney. We don't yet have a commencement date. Most likely that will be next month in May, but we'll give you more information as soon as we get that. The other thing, it's been a little bit controversial, but the other thing that we should remind you about is that the federal government has launched the COVID Safe app. The app does use technology to enable the government to identify quickly people who've had close contact with someone diagnosed with COVID-19. So that has been work that's been only being done manually to this point in time. So the app obviously is intended to provide much quicker action to stop the spread of the virus, provided sufficient people download the app. Now, I don't want to get into the discussions and comments and issues that people have raised around privacy. That's for you to determine for yourself as to whether you want to download the app. I'm certainly not going to give you any advice in that regard. You can have a look at the Prime Minister's media statement about the app. We'll get that up for you in a moment. I've downloaded it. Again, I'm not telling you that to encourage you one way or the other, but I would encourage you to inform yourself about it and then make your own informed decision about what you choose to do. One of the other things that has been very highly on the agenda, particularly in the last 24 hours, although it's clearly been an issue that the public, politicians, mental health professionals, and any of us, who are business owners or managers or trying to support teams, is the issue of mental health. And COVID-19 is apart from obviously causing severe physical symptoms amongst those who fall ill, particularly those whose health is not terrific, has obviously caused a significant amount of mental stress for all of us as we try to manage personal and business lives. That's one of the main reasons that we've got our wonderful consultant psychologist, Jessica, giving you a live stream update every Tuesday on strategies, tips and tricks, insights, etc., to help us take care of our mental health and be mindful of the mental health risks and wellness of our staff. So Jess will continue to be appearing every Tuesday. And all of our live stream recordings are available up on our Facebook page and on our YouTube channel and in LinkedIn. So feel free to go up and have a look at those at any time and send us through questions, including for Jess, anytime, and we'll answer those for you. We mustn't forget to really be paying good, close attention to our mental health and the mental health and wellbeing of our team. If you're an employer, you've got a lawful obligation aside from a moral and ethical one in that regard. So we need to be really mindful of that. My lovely team in a moment, I'm sure, are going to put up the contact information for Beyond Blue, for the Head to Health site, and also a couple of other options which are providing great strategies and information for mental health support. Okay, so the good news for Australia in terms of COVID is that the cases are slowing, the curve is flattening, but it will not continue that way if we don't stay vigilant. So also overnight there was an announcement that 10 million more new testing kits are on their way to increase our testing capacity. That's come through Minderoo, which is the foundation that Andrew Forrest, the mining magnate, has. There are some restrictions easing. I mentioned New South Wales will be allowing us to visit in twos other households from tomorrow, but by extension, the New South Wales Premier sensibly has warned us that easing will be scrapped if we don't follow the rules. So it's really important for us to stay safe and keep each other safe. There will be extra police presence in Queensland to enforce relaxed rules this weekend. And our Deputy Chief Medical Officer has assured us that Australia is prepared for a second wave of COVID if that were to come. And I mentioned that there's been a significant focus, ongoing focus, but particularly in the last 24 hours on mental health, and all Australians are encouraged to seek help when you need it. As I said, our team have put up some links there, but also you have telehealth available for mental health professionals. So you can get help anytime that you need it in that way, and there are Medicare rebatable services available and so forth. So please keep that in mind. All right, so let's move into our topic today, which is case studies on the JobKeeper Enabling Directions. So obviously back on the 24th of April, the Treasurer, I think it was at the time, provided clarification of the rules relating to the JobKeeper payment. And back on the 9th of April, the Fair Work Act was amended to support the implementation and operation of the JobKeeper wage subsidy scheme for Australian workplaces. So those amendments to the Fair Work Act that give life to the JobKeeper wage subsidy started on the 9th of April. And they will be in place until the 28th of September. So that is the period. They are only temporary changes to the Fair Work Act. They will be reviewed at the end of July. I mentioned that yesterday. So important to know that. As I mentioned before, and I've mentioned the last couple of days, the rules around eligibility or clarification as to how you can demonstrate a drop in turnover, eligibility of your business, eligibility of staff, etc., are frequently being reclarified, and tests introduced that will help expand the capacity of or the number and types of businesses that may be eligible. So please keep up to date with this. We'll keep you up to date every 24 hours during the weekdays, and we can do emergency broadcasts on a weekend if we need to. Otherwise, Mondays we're keeping you up to date on whatever's happened since the Friday before. But it is important for you to keep abreast of things that are changing, because you might have thought that last week, yesterday, that you may not have been eligible for JobKeeper. There's every chance that you may now. So very important that you keep on tuning in and finding out what might be relevant for you. So the new provisions, the changes to the Fair Work Act and the JobKeeper wage subsidy provisions enable employers who qualify for the scheme and who are entitled to JobKeeper payments for their staff to give directions that are called JobKeeper Enabling Directions. And what that means most broadly is that employers can therefore temporarily stand down an employee, either by reducing their hours or days of work, change somebody's usual duties, or change their location of work. So it also enables employers who qualify and who are eligible for payments for their staff to make agreements with their staff to change their days and hours of work and to take annual leave in certain circumstances. So I'm going to go through that, and as we're going through this, I'm going to give you the case study examples of how the JobKeeper Enabling Directions have been implemented in a number of different contexts. So the JobKeeper scheme is intended to provide a wage subsidy by the Australian government so that eligible employers can continue to keep paying their employees. That's essentially it in a nutshell. Interestingly, about 900,000 businesses across Australia initially registered for JobKeeper, but only about half have actually gone through with an enrolment. And I suspect that may be because perhaps people aren't accessing up-to-date information about how the rules and regulations are evolving and providing clarifications that mean that greater numbers than perhaps people thought would be eligible. So please get in touch with us, call us, email us, whatever means works for you, and we can help you determine that eligibility. And tune in every day, because we're giving you updates as these things are evolving. So if you qualify as an employer to receive the JobKeeper wage subsidy, you can claim a reimbursement of $1,500 a fortnight for all for each and all eligible employees who were employed by you as at the 1st of March and who are still currently employed by you. So that includes staff that you've stood down that may not be actually working but are still on your books. And I'm going to get to this, but it can also include staff that you dismissed after the 1st of March, but which you seek to rehire. So one of the things that has been made clear, and I mentioned this earlier, is that as an employer, if you're eligible for JobKeeper, you are required to include all of your eligible staff in your enrolment for JobKeeper. There are detailed eligibility requirements, but they are continuously being clarified. So please get in touch if you need some specific advice for your business around that. So eligible employees will be those, as I said, that were on your books, on your payroll from as of the 1st of March, and have been stood down or were dismissed after the 1st of March but have been rehired. So if you did make a staff member redundant after the 1st of March, then you're not obligated to rehire that staff member for the JobKeeper payment, but you can choose to. But you also need the agreement of the person whose position you made redundant to rehire them for the purposes of JobKeeper. If you do rehire someone, then you are required to include that person when nominating which employees you intend to claim the JobKeeper payment for. So payments will apply to eligible staff from the fortnight starting on the 30th of March. And the payments will be made for eligible employees to you as the employer by the ATO monthly in arrears. Now, this has created a whole lot of headache, I know, for businesses, to the extent that the 4 major banks came out about 48 hours ago and said that they had introduced direct hotlines for JobKeeper businesses to get support to pay those wages prior to receiving the reimbursement from the ATO. The fact of the matter is that you must, as an employer, have already paid that amount that is at least equal to the JobKeeper payment from the 30th of March. As I said, overnight, the determination has been made to give businesses until the 8th of May to have made those payments. Originally, it was you had to have paid it by today, so you've been given an extra 8 days to do that, and you need to make that payment before tax. So that's the gross payment, and then you obviously take tax out from that. So we'll put up some information as to whether you're an employer or an employee, where you can get further information about JobKeeper and eligibility. So that's JobKeeper more broadly. In terms of a business being able to give a JobKeeper enabling direction or to make an agreement with a staff member under the new Fair Work Act JobKeeper provisions, you must be a national system employer, so your staff must be covered by the Fair Work Act national employment standards. You must qualify for the scheme, and you must be entitled to payments for the employee to whom you're planning to give the enabling direction. Or create an agreement with them. So they are the 3 criteria that you have to meet. If you meet those criteria, then you are deemed a qualifying employer, and you can use the Fair Work Act JobKeeper provisions for each employee that is entitled to a JobKeeper payment, so an eligible employee for the purposes of the JobKeeper scheme. You can give an eligible employee a JobKeeper enabling direction or make an agreement with them under the Fair Work Act JobKeeper provisions from the 9th of April, which is when the new provisions started. You are only, however, authorised to make a JobKeeper Enabling Direction or an agreement under those new provisions during periods for which you can claim the JobKeeper payment for an eligible employee. So get advice from us in respect of that. Don't go ahead and start making agreements and giving enabling directions without advice, because you could find yourself in loads of hot water, and you don't need that on top of the impact of COVID-19. It is really important, first and foremost, as an employer, for you to confirm that you're entitled to JobKeeper payments for your staff before you issue any kind of JobKeeper enabling direction or you make an agreement. So we are actually cautiously advising clients and businesses that are making inquiries that they probably should wait until they've had confirmation from the ATO that they are entitled and eligible before. I know you can make those enabling directions from the 9th of April, but I think it's probably best safe to wait until you've had your eligibility confirmed before you go ahead. Talk to us, because there are other ways of doing it without having to rely on the JobKeeper enabling directions. Because obviously, as you would expect for any elements that are in the Fair Work Act, including these temporary provisions, there are protections for employees from an employer's misuse of the JobKeeper provisions. And like any other employment obligations that you have under law as an employer, ignorance is no excuse. I didn't know what I didn't know is not going to cut it if you do the wrong thing and it wasn't intentional. So the law requires you to know this stuff or to have in place expertise to advise you so that you make sure that you're meeting all your obligations, and that's where we can absolutely help you. So get in touch in respect of that. I might say at this point, just to remind everybody, that in this past week we have actually launched both a subscription service for HR support for businesses with us, and also 3 different levels of JobKeeper implementation packages to help you. We can do this with you and for you to make sure that you're doing all of the things that you need to do, as well as that you're making the most sensible and lawful and effective decisions for your business around your staffing at this time. So it's your obligation, if you're deemed an eligible employer for JobKeeper, that you must pay each and every eligible staff member that you have an amount that is at least equal to the full JobKeeper payment of $1,500 a fortnight before tax. You cannot, and let me be really clear about this, you can't reduce your staff members' hourly base rate through a JobKeeper enabling direction or an agreement. You must also continue to pay applicable penalty rates or other allowances that apply to the hours that your staff work. So if somebody worked enough hours during a fortnight that they're entitled to more than the $1,500 a fortnight before tax wage subsidy, and that will include penalty rates, allowances, loadings, leave payments, you must, as the employer, pay them the full amount. I need to be really crystal clear about that. The other thing I would say, because this is a question we've also had a number of times in the past number of weeks since JobKeeper was announced, and that is that as a qualifying employer for the JobKeeper scheme, you don't actually have to make an enabling direction or an agreement to a staff member under the new provision. So there is no compulsion. You don't have to do this. It's a provision that enables you to do it in circumstances that are reasonable and which would benefit your business. So you can give reasonable and safe directions for staff to work normal hours of work if they aren't already on authorised leave or other form of absence, and pay them either the amount of the JobKeeper payment or their usual pay for any hours that they work, whichever is the greater. So there is no compulsion or obligation to make a JobKeeper enabling directive or an agreement with your staff member if those things are in place. One of the interesting things that's come up in this question is, of course, the $1,500 payment also means that staff who don't normally get paid that much for the hours that they work are going to be getting paid, so in some cases, significantly more than what they would normally be getting paid. So one of the questions that we've had is, if a qualifying employer wants their eligible employee under JobKeeper to work additional hours, so those over and above their ordinary hours, while they're receiving JobKeeper, it's important for you to know that the usual requirements in the Fair Work Act are going to apply. Any additional hours that you ask a staff member to work beyond the hours that they would normally work has to be reasonable. So it has to meet that reasonableness test. A staff member can actually refuse to work unreasonable additional hours. So we've had a query from a number of employers saying, well, if I'm going to be paying somebody $1,500 a fortnight instead of $200 a fortnight, can't I get an extra $1,300 a fortnight work out of them? And if the only reason for a request to work additional hours from you as the employer is to match the amount of the JobKeeper payment, that's not likely to be deemed to be reasonable. So let me just be really clear about that one up front. And we've had that from a number of employers. You're also, aside from being eligible potentially for JobKeeper and being able to apply those special provisions that have been made to the Fair Work Act for the duration of JobKeeper, you also must continue to comply with any other terms and conditions of employment that apply to your staff. So award terms and conditions if they're covered by a modern award, an enterprise agreement if you have one, and their employment contract if they have one with you. So you must pay your staff members their usual base pay rate as outlined in those documents, and any penalty rates or overtime that may apply to additional hours worked when calculating someone's pay. So under the general protections provisions, and this is incredibly important to remember because we actually had, as one of the case study examples, we had an employer actually have their staff member say that they felt the employer was threatening them. And one of the things to force them into an agreement, one of the things that you need to be really mindful of is the general protections provisions in the Fair Work Act, which make it unlawful for you as an employer to force or be seen to try and force someone to work unreasonable additional hours or tell them that they have to work additional hours as a condition of receiving the JobKeeper payment. So let's give you one of the case study examples of this. So we have a trades-based business with a part-time staff member, and they normally work 30 hours a fortnight so that they can look after dependent children in their household at other times of the week. Their pay is normally about $1,100 a fortnight. Their employer would appear to qualify. Again, we'd be more comfortable to get that confirmation from the ATO before you determine that, but it would appear that their employer qualifies. And on that basis, they have started to pay this person $1,500 a fortnight before tax, even though it's more than their normal pay. To be clear, that staff member doesn't have to work any more hours in order to get the JobKeeper payment. So that difference between $1,100 a fortnight and $1,500 is not something they have to do extra hours for. If, and in this case, the employer did want to ask the staff member to work additional hours, it's unlikely that those hours would be reasonable and the staff member could refuse. And in fact, this is exactly what happened in this case. And we had the query from the employer, well, hang on a minute, if I'm paying them $1,500, can't I get $1,500 worth of work? What we explain to the employer is that if they ask the staff member to work additional hours for other reasons, then those hours might be considered reasonable. For example, if they had a sudden surge in work and ordinarily they would be asking their part-time staff members if they would mind doing additional hours. But in considering whether even making that request is reasonable, what we advised the employer was that they needed to consider any risk to health and safety arising from that person working additional hours, the workplace needs of the organisation, and the staff member's personal circumstances, including, in this case, their caring responsibilities, because they actually meet a particular requirement for flexibility under the Fair Work Act. So that becomes a significant consideration in whether or not they can be required to work additional hours. And any notice that the employer might give to the staff member about those additional hours. Also, under the particular award that this staff member is under with this employer, they actually get paid any additional hours as overtime. So if they were to come to some agreement for additional hours that were reasonable in the circumstances, then the employer would be obligated to pay that employee it needs to make sure that it includes overtime in its calculations, and therefore pay the staff member more than the $1,500 if that's what they're entitled to. I'm conscious that I'm 5 minutes over, and I'm just going to go through a couple of things, if you'll indulge me, because I think this is really important. The other major JobKeeper enabling direction is a stand-down direction, and that is where, if you're a qualifying employee under that scheme, you can issue JobKeeper stand-down directions, and for a staff member to work fewer days or fewer hours, including no hours potentially if there's no work in certain circumstances. But you can only do that if the employee can't be usefully employed for their normal days or hours because of the changes to the business that have come about as a consequence of coronavirus, or government initiatives to slow the transmission of the virus. You need to make sure, again, that reasonable test comes up, right? So you need to make sure that the direction isn't unreasonable. In order to give a JobKeeper enabling stand-down direction, so that's a change to hours or days, assuming it's reasonable, you need to let your staff know in writing at least 3 days before giving the direction, unless your employee is genuinely agreeing to a shorter time frame. You need to consult with them, or if they've got a representative instead, about the direction you want to give, and you need to keep a record of the consultation. Keeping your records through this process is critical, absolutely critical. You can't give a direction to someone who's on authorised leave or otherwise authorised to be absent from the organisation. So, and the other thing you need to bear in mind is that any eligible staff that you might give a JobKeeper enabling stand-down direction to continues to accrue their usual leave entitlements for the period that the direction applies. So their service and leave accruals are going to be the same as if you hadn't given them the JobKeeper direction. So we need to make that really clear. Also, redundancy pay and payment in lieu of termination of notice are also calculated as if the direction hadn't been given, if you consequently decide to make a position redundant. Any JobKeeper enabling direction stays in place until it's revoked or replaced by something else, or until the JobKeeper scheme finishes on the 28th of September, whatever happens first. You might also, well, hopefully not, end up in a situation where maybe the Fair Work Commission gives you a directive it has to cease. That's another option. Okay, let me just, you can also give a direction around changing duties or location of work, but again, the duties have to be safe. The person has to be reasonably licensed or qualified to do the duties you're asking them to do, and the duties need to be reasonable within the scope of the kind of work that your business does. I can't emphasise this enough. It's really important to make sure that any JobKeeper enabling direction isn't unreasonable, taking into account all of the circumstances that I've mentioned, including a staff member's caring responsibilities. If it isn't reasonable, it won't apply. So, okay, let me... okay, so... let me give you answer a couple of questions that have come in overnight. So one of them is, if I have my staff member working less hours than the value of the $1,500 JobKeeper wage subsidy, do I still have to pay allowances? for example, a tool allowance? The answer to that question is that employees must continue to be paid applicable penalty rates or allowances that apply to the hours they work. So, yes, you still have to pay allowances and all of those things that would normally apply. That's the answer to that question. Can I ask a staff member earning more than they would normally be with the JobKeeper wage subsidy to work additional hours to the equivalent of the payment? And as I've mentioned with the few examples I've given this morning, only if it's reasonable. If it's just to make up the difference between their normal pay and the JobKeeper amount, then no, that's highly unlikely to be reasonable. You need to take into account, as I mentioned, any risk to health and safety from having the person work additional hours, any workplace needs that the business has, the person's personal circumstances, particularly if they have caring responsibilities, and making sure that you pay them correctly relative to their terms and conditions in their contract, their award, or an enterprise agreement if they apply, about how additional hours worked is treated as far as penalties and all of those things go. One of the other curly questions we've had in the last 24 hours is, what can I do if I've stood staff members down, but I'll be claiming JobKeeper for them, and therefore want them to come back to do a range of duties and hours, so therefore give them ultimately a JobKeeper Enabling Direction. What if they refuse to come in and work when I ask them to? So I've stood them down. I'm letting them know that I'm going to be, I've sent them the form. I've let them know that I'm going to be applying for JobKeeper for them, but I want them to come back and do certain hours, not reducing their base rate of pay, all of that, making sure that I meet all of those obligations. What do I do if they say I'm not coming into work? First and foremost, make sure that all communications with your staff that you have are confirmed in writing. Failure to present for work could be a failure to follow a reasonable direction or even abandonment of employment. So you can initiate a disciplinary process if it's appropriate. Get advice before doing that, and make sure you have everything documented in writing. But yes, as an employer, you can deal with that situation appropriately as and when you need to. Do get advice before you do it, though. The other question we've had is, how do I handle performance issues during COVID-19? What happens if I have to discipline or terminate someone for poor performance or misconduct? Can I still do that? The answer to that question is you can and you should do either or both if the circumstances require for it, and after you follow due process. So due process is incredibly important at any time, in particular at the moment, because we know that there are rumblings and opportunities being sought at the moment to go after employers that are not doing the right thing, intentionally or otherwise. So due process and documenting the process that you follow remain critical in the event that the process or the outcome is disputed. So I had another question. I have this employer has asked, I have a casual employee employed regularly for well over 12 months who also has a casual job with another employer. They have just today been offered a temporary part-time 6-month contract by the other employer. If my staff member signs that contract, does that mean that I can't claim JobKeeper for them? Alternatively, if she doesn't sign that other contract, is she eligible? My reply to that was, if the staff member was on your payroll on the 1st of March and you were her primary employer and she is eligible for JobKeeper, then you can claim for her. You need to give all staff the ATO required form to complete, which I've talked about in previous sessions, but we'll give you that information for ease of access. It will also depend on who is the staff member's primary employer, so who they claim the tax-free threshold from. If this person was on the payroll of the other employer also on the 1st of March and eligible, then it will come down to who is her primary employer. Okay, so that is it. I've gone well and truly over time today. My apologies. This might have been best actually to chunk down into a couple of different sessions. We might pick up some elements that you might want to explore further next week. Thank you so much for joining us today. We are incredibly grateful for your attendance and participation. If you have specific questions about your business or want us to help you out, contact us anytime. The details are in the chat screen there. Tomorrow, you will have the great treat of hearing from our phenomenal administration coordinator, Jess, and her co-stars. I'm keeping that under wraps until tomorrow, so you'll tune in and get to see that, about working at home with kids, what it's really like and how Jess and her family are doing it. So please invite your colleagues and friends. We're really looking forward to tuning in to Jess's live stream tomorrow. Please, in the meantime, hug the people that you can, wave cheerily at those that you can't. Stay safe, stay home, wash your hands, and we'll look forward to seeing you tomorrow for Jess's live stream. Thank you so much.